up that clock for you. You can synchronize your watch there. Remember, Susan Lorincz charged with first-degree felony manslaughter in the fatal shooting of her neighbor, Ajike Owens. According to authorities, Owens was shot through the defendant's closed door after she went to speak to the defendant about a dispute over her children playing near the defendant's home. Lorincz told investigators that she admitted this, she threw roller skates at the children because they were running and yelling outside her apartment, "Get off my lawn." She eventually went back inside when Owens showed up to confront the defendant by banging loudly on the door. The defendant said she feared that Owens would break the door down, therefore she acted in self-defense. Lorincz says she did not intend to kill Owens when she fired her gun at the door. So today, closing arguments of the case. Let's listen now to the state. Here's again their closing argument in the Lorincz case.
There is no question in this case that the defendant was the one that fired the gun that shot and killed Miss Owens. She was the only one in the apartment that night. You heard crime scene investigator Catherine Medina, who processed the inside of her apartment, went into that bedroom and found that .380 Remington firearm in the trash can beneath that .22 Ruger firearm. Catherine Medina also found the spent shell casing that was found on the kitchen counter. Dr. Norford, the medical examiner, removed the projectile from Miss Owens's body. And you heard from Florida Department of Law Enforcement analyst Jamie Williamson, who said she took that firearm that was found in the defendant's residence, compared it to the spent shell casing found in the kitchen, and determined that that casing was fired from the defendant's gun. She also examined that projectile recovered from Miss Owens's body and compared it to the .380 Remington firearm, the defendant's, and found that the projectile in Miss Owens's body was fired by the defendant's gun. Finally, the defendant admitted during her interview that she was the one that fired that gun. She also admitted that the act of pulling that trigger and firing that gun wasn't intentional. It wasn't an accidental situation. It wasn't a situation where she slipped and fell and the gun accidentally went off and shot through the door and struck Miss Owens. That's not what we have here. She intentionally fired it. There's no doubt the defendant intentionally committed an act which caused the death of Ajike Owens. The evidence has proven that the defendant did act with utter disregard for the life of others. She pointed a loaded firearm towards a door, towards a person that she knew was there on the opposite side of the door, and intentionally pulled the trigger. That shows a reckless disregard for human life. It's an act which she must have known or reasonably known would cause death or serious bodily injury if that projectile struck somebody. The evidence has proven beyond any reasonable doubt that the act of firing that gun constitutes culpable negligence. The crime of manslaughter has been proven beyond any doubt whatsoever, ladies and gentlemen. The question in this case lies with whether or not she was allowed to shoot and kill Miss Owens under these circumstances. We know that these prior run-ins were the result of the defendant acting out or doing something towards the victim's children, Isaac and Israel. And at the time, we heard that Isaac was about 12 years old, Israel was about 9 or 10 years old. We heard that the defendant complained about the children, complained about them playing in this field, this open lot next door to her house. You heard that these children would play in that open field. They played football, they played some bottle game and some running around, what kids do. They weren't breaking into cars, they weren't vandalizing.
So ruled. Go ahead.
They weren't causing problems, vandalizing things, they were playing. And you heard from Frank Colon, who told you he was often out there playing with the children regularly to make sure they behaved. But as children do when they're playing, especially in groups, the children got loud. The children yelled and screamed and played to do what kids do. The defendant, the evidence has shown, didn't like that. She told the detectives in the interview she works from home, the loud noises interfered with that ability, she didn't like it.
Okay, so Mr. Buxton there really talking about a lot of the things the jury just can take for granted. Yes, she's the one that pulled the trigger. Ms. Lorincz shot the gun. There's no dispute over that. It hit and killed Ms. Owens. So Brian Buckmeyer's here and Catherine Lizardo. So Catherine, because it's a self-defense case, the jury's going to be looking at the top charge, first-degree manslaughter. That's up to 30 years. But the lesser included for some culpable negligence, far less severe penalties. They tend to come about when the jury thinks, it wasn't the best self-defense. Maybe she wasn't really reasonable. Maybe she overreacted. But we're not going to find her guilty of the top charge. What do you think in this case is possible based on this fact pattern?
I think it's possible for this case to get the top charge if the prosecution really hammers down about the recklessness. And that's what we hear during his closing argument. He focused that this is a reckless disregard of human life, the culpable negligence here, because even though she felt fear for her life, she shot that gun through the door. And here, what's interesting is they brought the actual door with a bullet hole at the trial for the jury to see. And there's picture of it as well, as we see there, and with a laser beam to show the trajectory of the door and the bullet. So it shows that she fired that in center mass. So that's a reckless disregard, knowing that that will hit whoever is behind that door. She might not argue intentional. That's why they could not charge her with second-degree murder, even though the family of the victim wanted that charge to be upgraded from manslaughter to second-degree murder. But the prosecution said that there's not enough evidence for that.
Yeah, Brian, this is really a matter of degree. Now, she suggests that when she was holding the gun, it was just kind of a warning shot. She felt like she was shooting high through the door, which happened to be not high enough. And again, it's going to come down to the jury putting themselves in her position, don't you think?
Yeah. So one is to the trajectory. I thought it was interesting when the defense put on their expert that at least from how I saw the diagram, it wasn't shooting like this. It was shooting like this. And even Susan Lorincz, when she's describing the shooting to law enforcement in the 2 interrogation videos that we saw, holds it appropriately. So I don't really put much credit into the trajectory that they put forward. If anything, I'm seeing that, that doesn't make sense. That's also not shooting up. If anything, geometry's not my greatest subject. That's shooting down, right? And so I think what really gets Susan Lorincz in this case is her interrogation videos and the 911 calls. What she says initially does not coincide with what her team is arguing. And then she doesn't take the stand, which she has every right not to, but none of her statements seem to correct it. It all seems like she's just kind of making it up after the fact.
Yeah, I'm kind of surprised we didn't hear from her. We know that from experience that that's the best way to even have a shot at a self-defense claim. Let's listen now to what the defense closing argument focused on to get this jury off of at least the top charge. Here we go.
If Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat. If you remember during the trial, Mr. Smith had asked some of the witnesses, did Susan shoot from way back there by her bedroom? Did she shoot from behind that countertop or behind that kitchen? It doesn't matter, because she has no duty to retreat, and she can stand her ground when she is in her dwelling if she is faced with imminent danger. Another important part of this is if she reasonably believed. We do not judge Susan Lorincz with what we in this courtroom have experienced in life. It's not what I would do, or Mr. Buxman or Mr. Smith would do in that circumstance. It's what Susan Lorincz reasonably believed was necessary to prevent. That's a very important word, prevent. When there's high consequences, you don't really know if the person on the other side of the door or the person that's confronting you is armed. Not just Susan Lorincz, but most people go to the fact that this person is armed, that they are a real threat. That's reasonable. And Susan Lorincz had no idea what Ajike Owens had on her. It's very difficult for someone to judge what is going to come next. And the law says that Susan Lorincz can defend herself to prevent the imminent commission of burglary, murder, or aggravated battery against herself. We heard the statement that Susan Lorincz gave to law enforcement. We heard 2 of them. And Miss Lorincz told detectives on the night of that incident, Miss Owens was pounding on her front door so hard the walls were shaking. She told detectives that Miss Owens was screaming at the top of her lungs and that Susan told her, "You're trespassing, you need to leave." Susan Lorincz told detectives, "I really thought she was going to break my door down. I really thought that. I saw the door moving in, and I really believed that. I honest to God believe that." That is what she said. She reasonably believed that. We heard Susan tell the detectives, "I heard Miss Owens say, 'I'm going to f***ing kill you.'" She heard that.
Generally, I kind of like that argument. I think it focused on the right things. I do have to do a fact check when she said that one of the reasons you could use deadly force is to prevent burglary. Well, that's a property crime. I'm pretty sure you can't use deadly force to prevent a property crime. But nonetheless, Brian, what do you think about her arguments here and the focus for this jury?
So yeah, I'm looking down because I'm looking at the jury instructions, what the jury will ultimately get when it comes to this. And again, I practice law in New York. We have very different self-defense laws in some regards in Florida. But the way that this defense attorney is describing how you're supposed to articulate or to assess self-defense is incorrect. When we talk about what is reasonable, that is an objective standard. Use that reasonable person standard, what objectively can be understood as to what is imminent deadly threat. It's not to say, well, she believes it's reasonable, then therefore it is reasonable. No, there is a subjective aspect to it, but that's incorrect. Because then anyone can just simply say, you know what, Michael Bryant walked up to me with a pink tie and a blue shirt and I didn't know what to think and it's reasonable for me to shoot him. Like, no, there's an objective standard there. And so I think she's playing loose and fast with some of these terms. That's going to really harm her when it comes to the judge actually explaining what those terms mean and the jury having to deliberate with them. Also, this wasn't imminent. You can't say, well, if this happens, then it's imminent. No, if creates a separation of time.
Yeah, and you point out the tricky part of the objective subjective standard here. It is subjective if you're in the position of that person, but it's an objective analysis of that person in that position. So I don't think juries make those nuanced decisions. They just say, she's nuts, she shouldn't have done that, she went too far, guilty. I think the real question is going to be of what, to what degree. Okay, guys, let's take a quick break. When we come back, we're going to have a stimulating conversation. That's what producer Alicia promises. The Tellus case underway out in Las Vegas, and we're going to get into